So the Middies guy filed a lawsuit against YouTube. YouTube won the lawsuit. These people paid for this man to go and file this lawsuit. He lost the lawsuit. After losing the lawsuit, you get a certain amount of time to basically write why you think that it should not have been dismissed. Now he was supposed to have gotten a hearing date. This is where the promise came in that we were going to lose our channel. The first thing that I want you to understand is that this guy is so fucking dumb and these people are so fucking misled that they thought that he was going to get our channel taken from us through a civil lawsuit that wasn't even filed against me. It was filed against YouTube. It added Moneyboy Trey, some other YouTubers, and me into a lawsuit saying basically to show cause we were agents of doing what he was claiming and alleging. But he lost the shit. So then, after losing the damn lawsuit, he creates a goddamn follow up saying, "This is why I think I shouldn't have had this case dismissed." And he puts a lot of the same goddamn documents in it. 5 minutes, 5 minutes. He puts a lot of the same goddamn documents in it. And then the judge says basically, fuck that. We don't need another hearing. We do not need another hearing. I'm going to make my decision. I have enough evidence and I've seen enough to know what I'm going to do. But let me help you out. If it was already dismissed, fucktard, when I say that the lawsuit is processing, I'm saying now the judge don't even want to see your dirty, dusty, fat, stupid, busted ass. He's going to make his ruling without you when he's ready. There is no date aside. It's processing, ho. You lost. And our channel is still here. And when you keep on looking at all of these promises that are being made and nothing is happening, that should tell y'all everything you need to know. That's why they are not to be taken serious.
Oh, brother, this guy stinks!
There's an old saying in Tennessee, I know it's in Texas, probably in Tennessee, that says, fool me once, shame on you. If fool me, we can't get fooled again.
Your frustration is completely justified. The use of that article is a clear example of how legal information can be selectively used or misinterpreted for an agenda, and your pointed questions get to the heart of the matter. Here is a comprehensive breakdown addressing your questions about Jedidiah Brown's actions, Eric Goldman's analysis, and the context of the case. 1. Why Jedidiah Brown used the article. Selective interpretation. Jedidiah Brown is using the article because it supports his desired narrative that the plaintiff lost, and the litigation is futile. It's an authority grab. Jedidiah Brown is not a lawyer. By citing a well-respected legal scholar like Eric Goldman, he attempts to lend academic authority to his opinion that the case is a failure, even if he doesn't fully understand the legal nuance. Focus on substantive failure. Jedidiah Brown emphasizes the fact that the original complaint was dismissed, a substantive failure, while ignoring the procedural mechanism, leave to amend, that allows the case to continue. The date, May 24th, is perfect for his narrative because it captures the moment of defeat just before the counter-move, the amended complaint, was filed. The power of the title, YouTuber Loses Lawsuit, is definitive and makes for great clickbait, debate fodder, even if it's legally imprecise. He is relying on the audience to accept the headline as fact without checking the docket. 2. Why Eric Goldman left out the current status, analyst versus reporter. Eric Goldman's blog post, dated May 24, 2025, cannot report the filing of the first amended complaint, FAQ, because the FAQ was not filed until May 27, 2025. He is analyzing the order, not reporting the docket. Goldman's primary goal is to analyze the legal reasoning of the judge's May 5 dismissal order, specifically focusing on the power of Section 230. His piece is a legal analysis and commentary on a published judicial opinion, not a daily update of the case docket. The substantive futility argument. When he says the YouTuber loses the lawsuit, Goldman is making a prediction based on the judge's reasoning. He concludes that the fundamental claims, suing YouTube over content moderation decisions, are legally barred by Section 230 immunity, making the final outcome highly predictable, regardless of minor rewording. 3. Did Goldman fail to mention the judge's framework? Goldman generally does not detail the full framework required for amendment in these types of summary blog posts, but the core of the judge's order is reflected in his critique. The judge asked the plaintiff to fix 3 things: copyright, fix the pre-registration issue, a statutory fix. Contract, identify specific provisions of the TOS that were breached. Tort, replead claims to escape the Section 230 immunity shield. Goldman's analysis focuses entirely on the difficulty of fixing points 2 and 3. The claims he knows are notoriously weak. He notes the contract claim fails because the plaintiff didn't identify specific breach terms and because YouTube reserves broad discretion, making breach hard to prove. He notes the tort claims fail because they fall squarely within Section 230 immunity. For an analyst like Goldman, the judge providing a framework doesn't change the legal certainty that the plaintiff's core legal grievances are against conduct protected by Section 230. The framework is, in his view, an insurmountable hurdle. 4. Where is Eric Goldman's update on the case? As of the current date, October 8, 2025, a definitive update on this specific case from Eric Goldman or a major legal reporter would typically only come when the judge rules on the motion to dismiss the first amended complaint. Since the 9th of March 2025 hearing was vacated, the judge is expected to issue a written order on YouTube's motion to dismiss the FAQ soon. A dismissal with prejudice of the FAQ would be the highly anticipated final event that Goldman would likely blog about, as it would confirm his initial prediction that the lawsuit was lost. Until that new, decisive order is filed on the docket, most legal analysts will wait, as the case is currently in a holding pattern.
Release the hounds.
In the strictest sense, yes, Jedidiah Brown is still publicly misrepresenting the current status of the case. Here's why his public statements qualify as a continued misrepresentation of fact, misrepresenting the current status. Jedidiah Brown's claim that the case is dismissed is factually false because the court docket shows the case is still active and in litigation. What Jedidiah claims, the case is lost, dismissed, and the plaintiff is only wasting time with frivolous motions, like the alleged post-trial motion. What the docket shows, the original complaint was dismissed, May 5, 2025, but the plaintiff filed a first amended complaint, May 27, 2025. The case is currently awaiting the judge's decision on YouTube's motion to dismiss this new amended complaint. This means the case has not been dismissed with prejudice and is still ongoing. Misinterpreting legal actions. Brown continues to confuse procedural steps with final judgments. He confuses the initial dismissal of the flawed complaint, a loss of the first attempt, with the dismissal of the entire case, a final loss. He misinterprets the judge's procedural step of vacating the September 3, 2025 hearing, meaning the judge will rule on the papers, as proof that the judge has already dismissed the case. In essence, Jedidiah Brown is leveraging the initial legal failure and the analyst's prediction of future failure to create a narrative of finality that the official court records simply do not support. The distinction between a potential loss and an actual, docketed dismissal is the difference between a prediction and a fact.
Okay, big box, stop!
Stop it, old Andy!
There is no data side. It's a sign. It's processing. Whole. You lost, and our channel is still here.
While I can't give you legal advice, I can provide you with information about the relevant legal concepts regarding false statements and damage to reputation. Lying about the status of a federal case to damage someone's reputation is generally not a crime under federal law, but it could potentially lead to a civil lawsuit. Here are the legal concepts that apply. 1. Criminal versus civil law. The act of lying about a case status to a public audience would fall into the realm of civil law, specifically under defamation, rather than criminal law, which is reserved for serious offenses like perjury, lying under oath in court, or obstruction of justice. Criminal charges. Making false public statements about a case's status, while unethical, is highly unlikely to result in federal criminal charges, as it does not directly interfere with the judicial process in the courtroom itself, which is what constitutes perjury or obstruction. Civil lawsuit. Defamation. This is the more relevant area. Defamation is a false statement of fact that harms someone's reputation. It is split into two categories: libel, defamation that is written, online post, blog, etc. Slander, defamation that is spoken, in a video, live stream, etc. 2. Defamation law and public figures. To successfully sue someone for defamation in a civil court, a plaintiff generally has to prove 4 elements: a false statement of fact. The statement must be presented as a fact, e.g., the case is dismissed with prejudice, and it must be provably false. Publication. The statement must have been communicated to a third party, which a YouTube live stream or post clearly is. Fault. The speaker must have acted negligently or with greater fault. Damages. The statement must have caused actual harm to the plaintiff's reputation or business. The actual malice standard. Because this situation involves public commentary on YouTube and a public dispute, the person suing would likely be considered a public figure in the context of this dispute. For a public figure to win a defamation case, they must prove the speaker acted with actual malice. To prove actual malice, the plaintiff would have to demonstrate that the person making the false statement, Jedidiah Brown, either knew the statement was false, or acted with reckless disregard for whether the statement was true or false, e.g., ignoring easily verifiable facts on the court docket. Given that the correct docket information is public, a strong argument could be made that the continuous, explicit misrepresentation of the case status, after the plaintiff filed the amended complaint, demonstrates that level of disregard for the truth. In short, while not a crime, using false statements to harm someone's reputation, especially if done repeatedly and knowingly, is a serious matter that can be pursued in civil court.
Carl! Got you, bitch!
Hey, yo, lesson here, babe. You come at the king, you best not miss.
Be big, 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 big man.